free since the pandemic hit, and we're going to keep it going as long as people, at least a few people, keep watching. I am broadcasting today from the sunny back deck of my house. I do some working in the house and some working at my office downtown, and I'm excited to introduce my guest today, Stephen Gary, and a friend of mine and fellow trial lawyer. Stephen, thanks for coming on the show today.
Pleasure to be here, Gary. Thank you for having me.
Absolutely, absolutely. So, Stephen, how do we know each other? How did we meet? How do we get connected?
I believe it was actually through your newsletters at your old firm. I think that I started receiving Cantor-Berger newsletters, and I believe I called your offices one time when I was just starting out. I had a question about a insurance company, and I believe that's kind of how things kind of get started. I believe we also know several of the same people as well.
Did I answer your question?
I believe so. Yeah. Very helpful.
And I know we've done some work together. I sent you. You've asked me to help out in a case or two, and I asked you to help out in a great case. You had a case that I sent you that I thought was a real challenge. You had a great result in recently, and you were featured in an article in the Lawyers Weekly as well. What was the major takeaway or major lesson you learned from that case?
Well, when I was originally, I guess, referred the case, there was a 50-50 word versus word situation. And what I learned was to make sure that each insurance company knew everything that the other insurance company knew. And that this particular case, there was property damage photos that one insurance company had that the other did not. So the insurance company that we went after, the at-fault party, didn't see this property damage photo, which made it more likely than not that our client was not contributory negligent in this accident. So I did see that article came out today in Missouri Lawyers Weekly. So happy to get a good result for a nice client.
That's great. That's great. Well, it's great working with good lawyers. So thanks for that hard work and that great result you got. So, so this is our Ask a Lawyer question. I appreciate you coming on as a guest. I want to talk a little bit about us, a little bit about your practice. But, you know, we have in 6 days, we have an election, and we have a new Supreme Court justice for 2 days. So, so there's a lot to talk about today on our Ask a Lawyer question. What I try to do on these things is keep it to answering questions. Let me ask you this about my newsletter. Do you still read my newsletter?
I do, yeah. I certainly do. I send out one as well. So I always try to see if there's any ideas from other lawyers' newsletters that I may want to incorporate into my own. So you were a very big influence in my original decision to do it, from going to your CLEs. And I recently sent a newsletter about election fraud. Generally, I also volunteer as a legal challenger, and I find, I guess, the history interesting of elections. And I, in my last newsletter, told a story about Lyndon Johnson. In 1943, he was initially elected to the Senate in a very close race against another guy by the name of Coke Stevenson. And in Texas at the time, there were political districts in rural areas that were not particularly well governed or maintained, and that people could get away with a lot when it come to putting dead people on election rolls, or just making up people. And that's
right.
What happened in a very close race, one of the closest races in the state of Texas. Lyndon Johnson was able to get a party boss in rural Texas to stuff a ballot box overwhelmingly for him. These are the types of numbers you would see in a dictator election, a sham election from Kim Jong-un or something like that, where 99% or 98% of people. Right. at the last minute. So there's a famous photo I shared with all of the political bosses next to this box 13 from the precinct that it was. And the issue ended up going all the way to the Supreme Court, where the Supreme Court decided that they didn't want to interfere with Texas's decision to not interfere with the election, essentially.
Right, right. Well, that's great. You know, it's a funny thing is that I think the same day you do, I read your newsletters. I love them. I like your voice. I can tell you do them personally, which is kind of the way I do them too. If anybody wants to get on, Steve's newsletter, email them at garinglaw.com. And if anybody wants to get on my newsletter, you can. I'm going to put a caption up on this too for my firm. You can email me at burgerlaw.com, and we'll put you in our newsletter because we do write about legal stuff. You know what? So I haven't read that book, but you know, Lyndon Johnson, for all the great stuff he did, he was one of the trickiest politicians there was. I mean, that was old school too. I mean, he literally stuffed ballot boxes. But I remember learning about that case in law school because it's an abstention doctrine, and it's a brilliant legal ploy. So what his lawyers did at the time was, and I don't remember the exact procedural posture, but rather than contesting any restraining order or anything in the state level, they immediately appealed. They immediately appealed the case to the Supreme Court because they knew about this abstention doctrine, where federal courts will be loath or reluctant to interfere in state election decisions because they're going to defer to the state law to do that, and our Constitution does defer to the state on that, either the 11th, I guess, or the 14th Amendment. So what they did is they went to the Supreme Court using this at that time more novel legal argument. They got the Supreme Court to agree. The Supreme Court stopped it, and Johnson became president. Brilliant, don't you think?
I do, yeah. I believe Johnson used as his legal counsel Abe Fortas, who he then later appointed to the court. Yeah, but the book that I read was a pretty famous book by Robert Caro. There's 4 installments so far, and I just finished the 4th installment. We're 3 months into his presidency. So he writes 4,000-page books about everything about him before he even gets there. And it shows you he's very Machiavellian, very end justifies the means. He was almost singularly focused on power and nothing else.
Yeah, and you know the echoes. So let's echo that to today, and let's segue that into our newsletters and our election in 6 days, if we could. The analogies to today are, to me, the quest for power and maybe ignoring other rules that I think we see going on. Interestingly, and appointing friends to the bench who you think may help you in a later election challenge. I mean, Trump specifically said, "I want Amy Coney Bryant on the court, so in case I need to go to the Supreme Court about this election, we want 9 people on there." So, what parallels do you see, if any,
between
the Lyndon Johnson time and now?
Well, I think it can also be contrasted to FDR. FDR had a hell of a time with the Supreme Court after passing his New Deal legislation. In 1935, the Supreme Court struck down almost everything that he had passed. So FDR decided, well, to hell with 9, I'm going to make 15 Supreme Court justices. That way, my legislation can't be overruled. And he proposed it. It was very widely unpopular, and it ended up at the last minute not working. I think it was called the switch in time that saved 9, that a few of the justices that were against him ended up supporting him. So I think that stacking of the Supreme Court is something that's always occurred in American history. It's not new, not novel to Trump. It's not novel to when Barack Obama tried to appoint Merrick Garland and failed. It's political, certainly.
So let's talk law and elections then. Some of my recent articles I've done on elections are to go off what you just said is that the issues of electoral college problems and issues are not new. They go way back. They go from the inception. Some of the challenges on voter suppression, voter intimidation go way back. Jim Crow laws. I saw that in the South in 1941, only 3% of registered African Americans voted. So we've had very effective voter intimidation, very effective. These things over time. What issues are you looking to? And I'm going to ask you one question, and then I see we got a lot of questions coming up on our feed here that I'm going to get to. But let me ask you specifically, either from a voice from history or juxtapose it with history, or now, what voting issues do you see arising in the next 6 days or after, or what do you see arising on November 3?
Well, I think the big one is the absentee ballot issue, and the states are having problems with their specific rules and how they want to address it. I think one of the reasons why Trump also wanted, the new justice sworn in is to address these issues in a conservative way before his election, right? So the problems that states are having are how much longer after the election do they have to certify election results, is my understanding, with absentee ballots pouring in. So I think that's going to be a potentially very volatile issue this election cycle.
Yeah, and I think the U.S. Supreme Court just handed down 2 decisions going 2 different ways, which I think harken this abstention doctrine from what we described. One came from a state court appeal, one from a federal court appeal, and I think the court went different ways. Now, we don't really have the time to get into the details on that. But here, I have a question for it right now. Sorry, go ahead, Stephen.
I believe Pennsylvania, which is a very important state for the election, is one of those states that's having this absentee ballot issue, and I don't think that it's been ruled on yet. My understanding that it has not, and I think they were trying to get that done fairly soon here in the next couple weeks if possible.
What's your reaction to, Maya asked this question, what's your reaction to the Supreme Court's decision on Wisconsin votes not being counted if they don't get in by November 3? And how does that, that's the decision that did come down. How does this bode for resolution if there's a contention in results or recounts?
So it's my understanding that elections, we hear elections on the news where they declare a winner, but they're not actually certified. The states haven't certified those results until a period of time after. And I don't know the specific timeline, because I think each place differs, whether it be 30 days or up until December 15th. So I think that if what was ruled in Wisconsin, it only counts if it was on election day, that's not a very good law. Not knowing more about it, I'd have to look into it more to know the ins and outs of why they ruled that way. But I would think that they would give states more time to count these absentee ballots in the event there is a contested election. Logistically, it's a lot to demand on states that they have all of their ducks in a row within a few hours of the polling places being closed.
Right, and here's the other interesting tie, and it goes to the second part of her question as well. So states control the election. The state law controls the election. Are there federal election laws? Yes, but the states do it, and then the states decide when mail-in versus absentee and the requirements of that, and ballot locations on election day, and when those are counted, that kind of stuff. So the Supreme Court was deferring to Wisconsin in that decision. Interestingly, though, that legislatures will decide those rules and or change that rules, maybe depending on how the wind's going to blow. Massachusetts, between 1800 and 1840, every election they flipped on whether all the electoral votes were going to go for the winner or they were going to divide them up. And it would flip and flop, and that happened a lot throughout our history. So if you had a Republican or if you had one party, a Whig or whatever legislature, and they thought the new voters may go the other way, they changed the rules. So, so the other thing is this Wisconsin issue, this ain't the first time this has happened. There's a history of that. But then the other thing, you're right, exactly, Stephen, on certifying is the states certify the election results when they do, and then their electors in the Electoral College go to vote, and when that is, and officially when that is. Now, most elections we end up it not being so close that you don't have to go through a contested Electoral College, but certainly in the Gore v. Bush time, it was hotly contested, and then in the litigation, and the question is, what is that vote for resolution? If there's a contention with the election results, well, what they do is they go to counties where the vote might matter and do recounts and that kind of stuff. For instance, remember in Florida, they were counting chads and counting ballots in those counties in Florida because that was going to be the one that was going to swing the election or not. So, in areas where it's not going to count because you're not going to catch up, they may not go in and count those. But in areas where they might, they're going to keep those ballots and they may get counted. So we'll see. Let me ask you this. Let me go through some more questions, if I can, Stephen. So there's, we mentioned at the start of talking about the new Supreme Court justice. And I'm reading a question from Adam who asks, what stands out to you when it comes to the confirmation of Amy Coney Barrett? Are you concerned about the way that played out?
I think that the process played out as it should have. I think that it was almost unusual in this day and age that there wasn't anything they found out about her. It seems like you can get dirt on everybody right now. It's just, the culture that we live in right now is very got you, So I thought it was very surprising that she passed without even a, like Brett Kavanaugh had, some issues from when he was a teenager that, don't really reflect his ability to be a Supreme Court justice, but they are things that people like to talk about.
Right.
I thought that was pretty unusual that she, I think she probably must be a very remarkable, candidate to have passed through so quickly and efficiently.
What do you think about the she's confirmed days after Ruth Bader Ginsburg died, and how that was treated differently, and within 8 days of the election. I'm walking around because I got to plug my computer in. Don't mind me. It's the fancy tech support I got. And juxtapose that or compare that to Merrick Garland. What are your thoughts on those differences?
Well, it just depends on who the majority is in the Senate and who's controlling the Senate Judiciary Committee, because that's where all the president's nominations go to be vetted initially before they're brought to the floor of the Senate for vote. So Obama had an issue with Merrick Garland in that Republicans were in control of the Senate, and they did not want to bring that up for vote prior to the election. Here, things are a little bit different in that, Donald Trump's Republican and the Republicans control the Senate. So you would expect the process to be faster, and it was faster because of that. People that control specific committees in the Senate have a lot of power in getting something to vote. I know John Tyler, who was our president in the 1840s, he nominated 9 different people to the Supreme Court within a few-year period. And because he came to the presidency due to assassination, he wasn't properly elected. He was a Whig in name, but he had alienated himself to other Whigs who were in control of the Senate at that time, and they didn't like him very much. So all of his nominations either were withdrawn or were stalled in the Senate Judiciary Committee. So I think that the quickness that a Supreme Court justice is able to get through depends, first on their character, obviously. That's a huge thing. But the political levers that can control it are, those that exist in the Senate. And if the party that controls the Senate is the same as the president, then things will go very fast.
All true. But, let's be crystal clear. The reason why it went fast is because we had an election coming up. It did not spring from the mind of someone unformed, I mean, so the impetus was they did not want to, in the event that Mr. Trump does not win, and we don't know what's going to happen. I'm never trust the polls or any of that kind of stuff, especially after 2016. But they didn't want to do a lame duck appointment, so that's why it was pushed. It went very quick, I think, from that, but even in times past, though, when a president, in more recent history, when a president has put up a nominee who was not palatable to the other side, let's say Merrick Garland, what the opposing Senate, and I'm reminded of Judge Bork, who people thought he was too conservative, and then he didn't pass muster. They withdrew his nomination, and then someone came in, and I forget who came in and was appointed instead of him. Maybe it was Clarence Thomas. You still, the president, though, still has the power to appoint it, and it's only with advice and consent of the Senate. So it's certainly not appointed by the Senate. So I do think that there's the hypocrisy there, and there's other issues. But you make a good point that this has been the politics around appointing judges have been contentious for a long time. That's nothing new. So that point is certainly well taken. Let me see. I saw. Yeah, go ahead. Go ahead, Stephen.
Can appoint a Supreme Court justice only temporarily without the Senate voting on it. And I think that's happened a few times in history, where if the Senate is outside of its term, the president will appoint someone temporarily, but that person doesn't get to stay on the court. The Senate process needs to play out in the Judiciary Committee and on the Senate floor before they can actually, get their commission.
Right, and I was thinking in hindsight. Now, I was wondering if Obama should have appointed Merrick Garland that way and have him sit on the court in order to really kind of stick it to the Republicans or not.
Well,
I don't know.
The timing of Merrick Garman's confirmation, do you remember? I thought it was around
10 months. It was in March. Scalia died in March, so it was 10 months before the election. Scalia died in February. Merrick Garland's name was proffered in March. Let me move to some more questions. These are all judge-related questions, Supreme Court judge-related questions. 2 questions, one from Kelly, one from Maya. What are your thoughts on justices going from one court to another court, not just staying in the Supreme Court for the entirety of their lifetime appointment? And then there's another question, should there be a limit to the time a justice can serve? Let me go first on this one, Stephen, and then I'll throw it over to you. Okay. So under Article 3 of the United States Constitution, all federal judges, from district court trial judges, Court of Appeals through the Supreme Court, we call them Article 3 judges because they have no term limit and they cannot be influenced. They're not running for election. Once they're in that position, they cannot be removed except by an impeachment process where they would be impeached and tried. That's my understanding. And so that's a big difference with an Article 3 because the founders, the Constitution, the framers wanted these judges to be above political bias and not political. Now they're obviously very political in getting the job in the first instance. So that's why there's not a time limit of where justice can be served. In terms of staying in a court or going to different courts, I've not heard of that. I've not heard of a Supreme Court judge stepping down and going to another job, although I have heard of Supreme Court judges stepping down to take other political positions and like an administration or doing that as well. So those are my answers. Stephen, anything?
I think you summed that up well. I think not a lot of people may know how judges are elected in Missouri. Missouri initially had very similar rules to the federal rules, and the governor would appoint judges, but they, after a while, didn't like that. I think in the 1840s, they decided that they were going to change it, so they made it where judges were going to be elected instead of having judges that were, elites, if you will. The populace didn't like, governor just telling them who their judges were. So in order to make judges a little more answerable to the people, that created, judicial elections. And that process has morphed into the system we have today, where a lot of counties still have those elections. In rural areas, it's a little bit better, but in cities or on the Supreme Court, I think it doesn't work as well, and they've changed the process due to that. You don't want judges spending, hundreds of thousands of dollars to get elected. It kind of makes the public perceive them as not as legitimate, in my view. So now in Missouri, there's something called the Non-Partisan Court Plan in the cities, and I believe it's for the Supreme Court as well. So Kansas City, St. Louis, the big areas.
Springfield.
Is it Springfield too? Okay, so yeah, they essentially have a list of qualifications for who may apply to become a judge, and a committee made up of judges, lawyers, and I think lay people as well. I'm not sure exactly who all sits on the committee. They give a list of who the qualified applicants are to the governor, who then selects or appoints judges, and after a year, they are up for a vote on retention. So the process in Missouri is a little bit different than, a Supreme Court justice, because you still have some sort of, election, or I guess an election aspect to it.
Great points. Yeah, the Missouri plan's an example for the nation. It tries to take the most popular counties and remove the politics out of them some, rather than have judges totally running. In Illinois, every judge runs for election every 4 years, including the Supreme Court. It's led to insurance companies trying to buy favor with judges. And there's a famous case in the Illinois Supreme Court where they ruled on they reversed a punitive damage judgment for $1 billion. They either reversed or cut it to like 200. They cut it substantially. One of the judges from Southern Illinois said that he did not have a conflict, and State Farm and he set out something where they had just given him a little money in his election campaign. Well, like 2 years after the decision, there was a FOIA or Sunshine Law request, and they found out that State Farm had paid the millions of dollars to the judge's campaign fund. And you can Google it. There's a lot of articles about that and how unfair that could be, both in terms of that happening in the first instance, as well as the lack of candor, the lack of transparency on the part of the judge and the litigant in front of the court. I mean, if Stephen or I are going against a defendant in front of the judge, we want to know if that defendant has contributed to that judge's election campaign. So that's gonna. I mean, because you have a right to change a judge, or you have a right to. There's laws about if a judge can, whether a judge has the appearance of impropriety in deciding, which should be the standard on deciding an issue. So here's and I want one more question on judges, and then move on. Some people are up in arms about the confirmation and swearing in of our most recent Supreme Court judge. So then the question is, hey, is that going to stay with her, Judge Barrett? Is that going to stay with her? Is that going to affect her down the road? And my answer is no. And I know that's kind of a, the answer is no. I mean, people forget this stuff. So, after a couple of years, she's just going to be another judge on the court.
Can you imagine if Supreme Court justices had an election? It would be bad. It would be very bad, I think.
It'd be insane. It'd be insane. How could you? I mean, we already have enough divisiveness in this country on elections. We don't need to add judges to the mix. And that's one of the wisdom, one of the great parts about our U.S. Constitution is this I don't know, this tower that they've built around these judges, that once they're in, and that's good for judges too. They don't have to look over their shoulder to a next election. We've heard, there's stories are legion about, you think the political orientation or political views of a judge, and that judge moving philosophically during his tenure as a judge, sometimes to the left, sometimes to the right. You never know where. I don't think anybody, and people think it's only the left, that's not true. I don't think anybody thought Justice Thomas would be as conservative as he has turned out to be. But people move to the left, or people try to balance the court, because the court still is a political animal and listens to the politics, which makes me hopeful for keeping some of the decisions that I think are challenged now. But with this newest justice, she's written against Roe versus Wade. Judge Hawley, our Missouri senator, sorry, my phone's ringing, just his press conference literally a day ago he literally said, this is the most conservative justice appointed during my time, and I think Roe v. Wade's going to get reversed by her. That was our sitting Senator Josh Hawley's press release within a day of her being confirmed. And I think Judge Barrett has already written against the ACA and the mandates and some of the issues in the ACA, and she's going to rule on that in a month. So let's move on. I think we've talked as much on judges, and unless you have anything else to add, Stephen, I think we've talked on judges in the election sufficiently. Anything else to add before I move us to some other issues?
I don't think so. We covered it pretty well, unless there's any more questions.
If there is, I'll jump on it. Well, here's a question. Are lawyers allowed to serve on a jury? This will be our segue. What about judges and lawyers? Can a lawyer serve on a jury? Number one. Number two, could a judge serve on a jury? Can a federal court judge be called to sit on a state jury, or vice versa?
Now, I know lawyers can. Whether a lawyer would want another lawyer too is an entirely different story. During the process, what's called voir dire, where you select a jury, I think you probably wouldn't want another lawyer on your jury. But maybe you would, I guess, if they were also a plaintiff's lawyer. But I think the other side would probably strike for cause on that. As far as federal judges serving on juries, I've not heard that they can't. Do you know that?
I don't know. I think I don't know. I think that they could get a for cause. I don't think there's any I think you would have an equal protection challenge if you had a law singling out a somebody. But I don't know. It'll be interesting. You know what? Maybe we'll see. Either you or I. Let's put that in one of our next newsletters.
In its practical application, I don't think it'd happen. I don't think you wouldn't want a superstar, like a movie star or a professional athlete on a jury either. I think that would really detract away from the trial. So I think probably all sides would agree to not select that juror, is my guess as how it would actually work out.
Although lawyers do serve as jurors. They changed the law in Missouri a couple of years ago, so lawyers they're not automatically disqualified. And I sat on a voir dire when I lived in the city before I moved to in the city of St. Louis, and I know other lawyers who have served. So now the reason why some of the reason you don't want like a federal judge or a lawyer on, because we know the law, we know what evidentiary rulings may be made and what the judge may be excluding from evidence, and we may have insight to it that it may not be fair, or we may be able to have undue sway or undue influence over our fellow jurors, and that's not fair. That's not a fair representation of our community. Not that someone would act on that, but that is that potential.
Do you know if you've had a lawyer on one of your juries before?
I have. I've picked juries where I have had them. I'm trying to remember if they've actually sat. I think I've had paralegals. I've had paralegals for sure. I've had other people working for law firms. I think I sat I know I did have a lawyer who wasn't a litigator. He was like a something else, a trust and estates or some other person, and I was comfortable with that. All right, so let me move on. One of the things that's similar between Stephen and I, not just our youthful looks. Just kidding, Stephen. I'm older than you. Is that we're both personal injury lawyers. We both represent individuals and we both fight insurance companies. So we have a line of questions on our feed here, Stephen, about those issues, and I thought I'd ask you some of those. So why don't I've gone first? Maybe it's your turn. Let me throw this one to you.
Okay.
There's a bunch of them. Here's one from David. Are there any types of cases the insurance companies are more likely to settle? Does it have to do with case type, such as car accident or slip and fall, or is it based on the settlement financial request, a higher demand or something? The higher amount, the less likely they will be willing to settle without a trial. So so that was a long question. Coming back to the first part of it, are there any types of cases the insurance companies are more likely to settle faster?
Well, I think if you have a case with a very sympathetic juror, a very sympathetic plaintiff with a lot of damages and liability that's very clear, then that's a case the insurance company might be more motivated to settle. I don't think the amount that you demand has much to do with it usually. Insurance companies will probably pay what they value the case to be, either earlier or later on. They're not going to decide to give someone money because they demanded more money. The cases I can think of are, a drunk driver hits a family and their kids are injured, very seriously. There's a certain amount of money for that policy. They'll probably, give that money quicker than on a case where how the accident happened is disputed, where one party says one thing, the other party says another, and the injuries weren't as bad. Usually, cases where the limits of an insurance policy are lower and the amount of damages suffered by the person is high, you typically see those cases settle more quickly. So I think it's a very case-by-case basis. You can't really make too many generalizations on, how a lawyer approaches a case necessarily and relate that to whether a case will settle quickly or not. But you can, I guess, see certain things that, like I discussed, that may make it settle more quickly. What do you think?
I think a great answer. Can I ask you can you move yourself to the right or your camera to the left a little bit, center yourself? There you go. That's a little bit better. Thank you. Sorry. And I move around when I talk. Shoot, I was walking around a minute ago. It's all good. You're exactly right. You're exactly right, Stephen. So it's like anything. It depends. So so if there are, but I would say medical malpractice and products liability cases are usually harder to settle. I usually don't try to settle them in a claim stage. It means I'm filing suit on those cases and litigating them, and then I'm talking money, because that's the only way I get their attention, frankly. And I've tried to do it the other way to no avail, and my clients are like, why do we delay this? Let's get this thing on file. There's also shorter time limitations for medical malpractice cases. You need to get those things moving. In terms of other cases, so like types of cases like slip and fall, premises liability, or auto cases, or truck or motorcycle, that's what you were talking about a minute ago. It depends on liability and damages. So on the liability side, so I guess the answer to the question is there's a lot of variables in a lot of cases that can affect the timeline of settlement. I have cases all the time where I have clients, like I settle a case on the eve of trial, the client's going, I go to the client, remember when you came in, you said you didn't know if you needed a lawyer because this was a straightforward thing and the case should settle easy. And then we fought this for 2 years. And then, so, I mean, and you're laughing because you see that all the time too. So, yeah, but if there's contested liability, or if the defendant lied in the police report and said, no, I had the green light, and your client says I did, then that's going to go longer. That's harder to settle because the insurance company has something to deny it on. Or if there's comparative fault on your legitimate comparative fault on the part of your client, or if it's a slip and fall, if they're saying, no, I had no knowledge about the ice that was there or something like that. So if the defendant, the insured, comes up and creates a defense, that can delay things. And I often wonder why we litigate these cases, and I'm like, you have insurance. Why are you fighting this? Why are you making a story about this? Is not coming out of your pocket. But then on the money side, on the amount of the demand is one of the things. You're right, though. You correctly pointed out insurance policy limits can affect it. If the damages are way above a policy limit, sometimes that's easier to settle a case. But the other thing is connecting the medical damages. So if you have a medical situation where your client is an old guy like me, not a young guy like you, and older people will have more degenerative conditions in their back, or they'll have, and all the medical on this, Stephen. So the insurance company will try to say that the injuries, and they'll attack it from a causation point of view rather than a liability point of view. They'll say from a causation point of view, you didn't cause that herniated disc in the neck, or you know what, you're an inability, you have a meniscus tear, but when they went in, they found other problems or this kind of stuff in your knee. So the defendants will try to muddy it up on the medical causation too. Or your client your client had an accident 3 years before about the same part of their body, or that kind of stuff. So there's different ways that can delay it. And then lastly, and I know I'm talking long, but one other point and I'll be done, is there's a tension between getting money fast and getting a good settlement. So if you want to, clients who want to get a high money resolution in their case, and many times deservedly so, that sometimes doesn't happen quick because the insurance companies, they have their they've done the math, and they know if they can pay less sooner, quicker, and you force them to trial, you file suit and do these other things, is sometimes when you get the good money. I wish it wasn't so, but on the other hand, it keeps me in business. So there you go. Anything to riff off of what I said, Stephen?
Yeah. So what you said at the end there reminded me of what the late Ed Brown said about settling quickly. If you settle quickly, you usually settle cheaply. So I try to tell clients that, sometimes you don't want to take the first offer on the table because it's not what your case is worth. And to get your case to where it's worth requires work and time. It's a process that doesn't, just happen overnight. It's a process, I guess is what I always try to say. So
how'd you know Ed?
I didn't know him well, but I used to see him fairly often down at the criminal court dockets. And he also played tennis pretty close to my house over here. So I've talked to him a handful of times. Always very friendly, nice guy. I was very sad to see, the news yesterday. He always had a story to tell in my, dealings with him. So yeah, I was very shocked, probably like everyone else.
Yeah, Ed, what an honorable lawyer, and my heart breaks for Dan Brown and Ed's family and Dan's family and everybody at the firm. It's very sad. Ed, what a great character, strong person, which in terms of lawyers who advertise on TV, they broke the mold in terms of being quality, hardworking, dedicated lawyers. Not that I'm. People have this view of lawyers on TV, and if you watch some of their long stuff, they were great. I loved them. I would watch them. As a competing lawyer. They're just with their mom, and just what a great family and what great hardworking lawyers. It's just heartbreaking. I can't even talk about it, honestly.
I moved to St. Louis in 2011. He was one of the first lawyers that I saw, because of his advertisements. And learning his reputation and seeing it was so high was, I guess, something that I wanted to, I guess, model my career after in some ways, because a lot of lawyers, they advertise a lot, and I don't mean any disrespect to anyone specifically when I say this, but some of the bigger personal injury lawyers that advertise a lot through TV and billboards don't necessarily have that reputation, and you don't hear other lawyers talk about them as reverently as was the case with that.
Very true. Very true. Well, thanks for bringing his name up. That's great. I'm really glad you mentioned him. It's tough to talk about, but I'm glad you did. Let me move on. Why do you think, here's another question. Why do you think there's not more pushback on insurance companies when they deny so many claims without an attorney? Can you expose some of the evil ways of dealing with the insurance companies? Let me take a turn and go first with this. Or is it your turn? I don't want to be hogging the mic.
It doesn't matter. You can go ahead if you want.
So there is pushback, but by lawyers, and when you get injured, there are, but in the media, there isn't, because the insurance companies just say, we're looking out for our shareholders and we're not paying frivolous claims. I remember when George Bush was running for president, he would say, people are paying all this money to settle frivolous medical malpractice claims. And I'm going, medical malpractice claims are the hardest defended cases. No one's paying frivolous money to these cases. Are you kidding me? And so there is pushback by us as lawyers, because we know the market and we know what cases should settle for what money. And it really is aggravating to me as a lawyer when a client has to wait another year because the insurance company is fighting them so hard, and we settle the case for the money we should have gotten a year ago. And we're doing it on the eve of trial when they should have done that earlier. So that's really frustrating, because our clients, Stephen and I's clients, take significant financial hits, both in terms of medical expenses, losing their job, that kind of stuff. I counsel clients all the time about, listen, you may need to get a different apartment. You may need to move. I have literally today, Stephen, I had emails from bankruptcy trustees for two of my clients who I had to email back and say, I'm sorry, but we're gonna protect this asset in bankruptcy. So, and then to the second part of the question, can you expose some of the evil ways of dealing with insurance companies? Yeah. So if you're settling a case on your own and you don't call a lawyer yet, that's fine. If you've got like an ER visit, and maybe you put your more money in your pocket without me or Stephen, but they'll do things like they'll say you were comparatively at fault when you weren't. They'll say things like, we don't have to pay for your medical because you had health insurance. We don't have to pay for your wage loss because you had used vacation pay from your work. All those are not true. They'll say things like, we don't have to pay for, we don't have to pay for chiropractic treatment because we don't believe it. They'll say things like, oh, it was just a small fender bender. You didn't have enough damage to warrant damages, so we're not going to pay you. They'll say things like, we're only going to allow 2 months of treatment. We're not going to allow anything beyond that because that's not justified by the injury or that kind of stuff. They'll do things like say, lawyers are going to take all your money and a fee and stuff, so you're going to put less money in your pocket when you're going to lawyers. All those are untrue. I know
the provider doesn't bill consistently with other medical providers in the area. That's one I see pretty frequently, which I think is very misleading, because I don't know if any insurance company has that data to know exactly what is being billed in a specific area specifically. I think that's just somewhat of a lame argument used to try to devalue care.
And us as lawyers handle that for our clients, not the insurance company for the opposing party. At the end of a case, I reduce liens by providers. If I have a provider who charged $10,000 for an injection, I call them up. I say, that's not fair. We're going to reduce that. And I work very aggressively to reduce the liens to what is a fair market value. And I have ways to knowing that, like I use insurance I use healthcare insurance, not auto insurance, healthcare insurance information, payment, reimbursement rates, that kind of stuff to get a fair price. Stephen, I'll throw it to you again. What are the other scams or evil things insurance companies say?
I think the most evil thing an insurance company does to someone who's just been in an accident is that they will try to get that person to settle their case very quickly before they hire a lawyer and before they really even know how injured they are. I had someone called me a few years ago, and I'll never forget it. This poor girl was 19 years old, was a passenger in a car with the driver was a drunk driver. He rolled the car several times. She broke her hip and had a broken knee, and she was calling me to ask about something unrelated to the car accident because she had already settled her car accident case for $500 and a promise to pay the medical bills later on. But she hadn't fully healed yet. She hadn't gone to physical therapy. She didn't really know, what would happen. But she essentially was taken advantage of because $500 seemed like a lot for that moment, and she needed $500, to get through the next few weeks. So she took it. I think that's the most evil thing that insurance companies do, to aggressively deal with unrepresented individuals and get them to settle their case for pennies on the dollar. Not every case is worth a lot of money necessarily, but I think if you're injured and you don't know how soon this problem will resolve itself, you certainly should never just take the insurance company's first offer, because they know they can get a certain percentage of people to settle good cases for a fraction of the value.
Yeah, let me echo let me echo that a little bit. And that, yeah, so they've done the math on it. And so they have aggressive ways of contacting people who are recently in accidents, throwing a couple grand over their known medical bills at them, trying to get things done quickly. And they'll say, you need to get done by 5 o'clock today. We need to get this done. We're going to come in. We're going to investigate. We're going to do this and this. Don't go to a lawyer. And they try to keep it in-house they try to control it. And when they're doing that, they're trying to underpay people because people don't, in terms of the medicine and the injuries, no one is going a day after an auto accident and getting an MRI or finding out that they need neck surgery later or finding out that there's really a fracture in their vertebrae, even though it's non-displaced now, or that, and I can tell you, and I know you gave an example. I have examples too when people have settled these cases and done. That's the other thing is I literally have a case right now, Stephen, where I have filed suit where they had my client sign a release for under $1,000, and this person has significant problems, and they thought it was for property damage only. They'll say it's for property damage, and you're nodding, you've seen that. And then now what I did in that case, they sent me the release, and I said, that's fine. You sent me the release. You say it's signed. You say you sent them a check. Send me a signed release. There is no signed release. There's a release, but they didn't, and they sent them a check. And then I said, show me on the check where it says accord and satisfaction. And it didn't say that. So we filed suit in the case and we're fighting it. And remember, folks, that a release or settlement is an affirmative defense to a case. And you can challenge a release or a contract and set it aside for fraud. And I've done that too. Fraud and misrepresentation, because there's a duty in contracts to add in good faith and deal fairly, and you shouldn't make misrepresentations to get someone to settle a case in a release contract any more than it'd be fair for me to lie to you about how bad my car is and sell you a lemon. You can't do that. There's laws to protect it. There's consumer fraud laws to protect that. You can have a Missouri Merchandising Practices Act case against that. So you hit the major one. Thank you, Stephen, for saying that, because you hit the major one. This quick, let's settle early. They are setting you up. If they wanted to be fair to you, they'd say, you know what, you wait. Make sure you don't need more medical care. Make sure you're all taken care of. What if you get fired from your job because of this, and then you have another 20 grand in wage loss damages? There's a whole cascading things that happen after a bad wreck that where people shouldn't rush out and settle these cases.
I think the perception that all lawsuits are frivolous, that has kind of come about since, I guess, the 90s or whenever the tort reform really picked up steam, has hurt, or I guess it's helped insurance companies, but it's hurt people in their actual situations, because they think, well, I don't want to talk to a lawyer and discuss my problems, because that would be frivolous for me to do so, or that would be, encouraging the system where you get money for something you don't need. And I think that people have to realize that personal injury lawyers exist for a reason, and that's to help you in that situation, because people are actually hurt. There's a small percentage of, like any industry where people do things for illegitimate reasons. I think the perception in our industry, especially, is that percentage is much higher than it is. So I think the tort reform movement,
unfounded. It's unfounded. It's unfounded. Yeah. Sorry, go ahead, Stephen.
Oh no, that's kind of all I had for that. Yeah. Although I did want to say one thing about the release. In your case, did they get a oral release of claims, like over the phone?
Written.
I had to fight. Well, you said it was written, but
it wasn't signed. An oral release isn't binding.
I've had some insurance companies fight me on that recently, and I've been able to get them to to overturn the decision. But there is case law out there that says that it maybe is.
Well, no, it's a statute of frauds issue, and you can compel a settlement. Sometimes you can, but if you could show it's a statute of frauds or there was not a meeting of the minds, it's harder to show under an oral contract to the meeting of the minds. You get your client to say, "I just was settling property damage. I didn't know this. I didn't know that," and then a judge will not do it. So even lawyer to lawyer, it's really hard to enforce an oral settlement. So if I find, because it's hard. I mean, unless the other side says, "Yeah, we had a deal." So I would fight those if it's worth it. Now, let me do. So we're at an hour, Stephen. Let me fly through some other quick questions. I got my last one here. This is a good question. Are there other options for an injured person to get financial help quickly besides settling quickly for a fraction of the value of their case or taking out a loan? Stephen?
To get their settlement money quickly, are there other options other than the settlement?
Are there other options? So if you're hurt and you got money problems, are there options that you have other than settling with the insurance company? Because that's the hammer they got over our clients or our potential clients who haven't come to us yet.
Well, a big one that some people choose to use, I don't necessarily always encourage it, is you could always get an advance on your settlement from one of the companies that provides that service. There are several, in the area that do that they charge an interest rate based on how long the case takes to settle. Sometimes that's right for some people, but there aren't a ton of options for people if you are missing work and you can't get money right now. I don't think, unless I'm wrong.
Well, no, you're right on what you said, but I have some other options. So there are some other things you can do. One thing you can do, so I probably have 7. Let me see if I got them right. So one thing you can do is you can tell the insurance company, give me an advance. I'm not going to sign a release, but you want to be so fair to me, give me $5,000. And then we'll take that off the settlement later. You may have, that's 1. 2, you may have med pay. So you may have med pay on your own insurance company. You get your medical bills paid for. Use your health insurance. Use your health insurance. That should pay for all your medical. If you come to Stephen or I, we have doctors and medical providers that we know that will treat on a lien basis, meaning they will, if it's a case, that they can get you some care and they will get paid out of the case. Just like every other case, just like even if you go to Barnes Hospital or something, if you're in no pay, they'll treat you, but then they'll put a lien on the case. So then there's I teach lien law. I did so last week. So there's a law in Missouri where medical providers can put liens in cases and get paid out of it. So then now lawyers can't and don't give loans ethically, but there are other loan companies. I highly discourage them because it's really high interest rates. But there are other things. So there's government benefits. So can you apply for Social Security disability? Are there any other ways for you to get paid some wage loss damages? That you can try that. Then sometimes your employer will give you, talk to your employer. Maybe you have vacation, maybe you have sick, maybe you can go to your vacation for next year. Maybe you can do something while you can be off work. Maybe you can talk to your employer. Maybe they'll give you some light duty work. Maybe you get paid something. Maybe you can do something. So I don't know if I got to 7, and I'm sure I have other ideas. But the other thing is you got to remember, if you don't have a big bank account, a bunch of money saved and stuff, you're going to take a financial hit from this case. But it's smarter for you to trade in the truck and buy a cheaper car, or to move from an expensive apartment to a cheap apartment, or decrease your monthly nut that you got to spend and hold out for a year, get the surgery, get all the stuff, because on the back end, you'll put so much more money in your pocket, tax-free, in a personal injury settlement. So that's what you should do.
I think at loan advance companies that sometimes you maybe might want to settle more quickly to repay things and get it over with, rather than let the process play out as it should.
Right. All right. I got my last question. I will put it up here and I will answer it first. So we started with history, Stephen. I know you're a history guy. Let's end with history. If you could sit in and watch a historical trial, what would it be? Well, do you have an answer? I kind of have one. So, here's one that I would have liked to see. So right around the birth of our country, President John Adams defended the British officer who killed Bostonians in the British Tea Party. So in the British Tea Party, the British soldiers who shot on the Americans. So the Americans came, they threw a bunch of ice balls and stuff. The British freaked out. They shot, they killed some people. So our President John Adams, who was a true trial lawyer, and he went and he defended the defenseless. And they didn't charge the rank and file, they charged the sergeant. And he went in there and he tried that case and he won it. And he got everybody acquitted other than the sergeant. The sergeant wasn't hung. He had some lesser penalty. But to me, when you were talking a little bit a while ago about images are, the public image of lawyers, and, injury lawyers have a slammed image because of a huge marketing effort on the part of insurance companies for a couple decades. It's not anything we did. It's what insurance companies have marketed. But to me, that's always an example of a selfless lawyer taking a hard client, a hard case, not worrying about his future, doing what needed to be done, doing it right, doing it, zealously advocating for his client. That would have been an interesting trial to watch.
Certainly, yeah. Well, I think I would have liked to sit in the trials from the French Revolution. I think those would have been interesting. Although I don't speak French, so I guess I'd have to learn that in this hypothetical.
Bring your phone, bring your Google Translate. Why would that be cool? Why would that be cool?
Well, it's just a very interesting time where things were changing very rapidly. And I am trying to remember who the main individual on trial during that time was. And I don't want to say it for misquoting it, but I remember reading about it in college and thinking it was very fascinating.
Was that Robespierre? No.
Robespierre, yeah, but I was hesitant to say that in case I was wrong.
Well, you and I both said it, so let's just pretend like it's true. Right. And then hopefully no one will watch it and correct us in the margin. I can't believe I pulled that out. So what would have been interesting about it?
In addition to that, I think I would like to see skilled attorneys during a trial. Like, for as much as people talk about OJ, I would really like to see the OJ trial live, because I think their defense strategy and showing that OJ's glove didn't fit and how that played into their overall narrative was a very, very persuasive tool that eventually got him acquitted.
It worked. That trial was way too long for me to watch it. On the French thing, I mean, they won all those trials. All those people were executed and beheaded. So that would have been, I guess you could, if you watch the trial, then they go out and take them out and behead them. So there wasn't a lot of time for appeal.
There wasn't a lot of time for appeal, no.
All right. Well, listen, we're coming to the end of our time. I would thank again my guest, Stephen Gehring, GehringLaw.com. Thank you, my friend. Thanks for doing this. There's a great discussion today. I really appreciate you just talking these gamut of issues with me. I appreciate it.
Yeah, thanks for having me on. Appreciate it.
All right. So Stephen and I have another thing in common. We both answer questions for free all the time. So if you have a question for Stephen down the road or want to get his newsletter, go to GehringLaw.com. If you want to ask me a question, go to burgerlaw.com, email me at gary@burgerlaw.com or info@burgerlaw.com. Happy to talk with you. All right, everybody, please vote on November 3rd. I think the next time I'm doing this show, it's going to be after the election. So we got a whirlwind of events coming up in the next couple of weeks in our country.
We certainly do.
Thanks, Stephen.
Thank you. Appreciate it.